Hello, good morning. I'm Jeremy Davidson with SFAR Education and Events, and I'm very pleased to announce our special guest for today, Patricia DeFonte, who is with DeFonte Law, and she is here to talk to us about vesting and title issues that can come up during our transactions that affect both buyers and sellers. So we're really happy to have her here today. She's going to spend about an hour with us with a presentation. We should have some time for Q&A at the end, but please feel free to put your questions in the Q&A section of the Zoom. And if there are points during the presentation that make sense for us to tackle them, at that point, we'll do that. Otherwise, we will reserve some time at the end for them. So without any further ado, welcome, Patricia.
Thank you so much for having me here. I have a soft spot for people who work in real estate. My dad was an award-winning realtor. He started his own Century 21 offices. He had three down in San Jose in the 80s, and the gold jacket, the magnets on the side of the car, like the whole thing.
Wow.
I know. And when he retired, he started building houses on spec. And so it's really hard for me to drive past an open house. I want to go in. I want to see the
Well, stop
finishings. I
in
want to see
anytime.
everything.
We love
Um,
open house visitors.
love open houses. Um, Multidisciplinary study is a value for me. So I have learned a lot from realtors. And I hope that you guys will learn a lot today. Not a lot that will make you dangerous, a lot that will make you a great referral generator and an issue spotter. And I'm wondering if you guys could just drop in the chat who here, does anybody here own real estate? I would love to get an idea of who owns real estate. And I know that I can see how many participants we have. And so I know how many responses I'm waiting to get. And I'm also wondering if you own real estate. Oh, I see. There's a Q&A section on this. Ah, I see. So the chat is disabled. Okay, I got it. So you can also put these in the Q&A. When you bought the real estate, how did you know how to vest? How did you know whether to take title as a married person but separate property, or as a tenant in common, or community property, or a joint tenancy? Hopefully, you worked with a lawyer to help you figure this stuff out, because the answer is always, no matter what, it depends. There is no go-to answer that works for everybody when it comes to vesting. And so most of this is going to be a screen share. So let me get my presentation up. So we're going to talk about real estate vesting issues and options. So I can't give anybody any legal advice today, because the answer to any legal question is, it depends. It's the application of all of the facts to all of the law. Oops. This is me, and a little bit about my firm. I'm on year 5 of super lawyers. I think they send me a cape this year. We keep getting voted best of the Bay, which is pretty cute because we don't campaign for that. We also have a torch award for ethics. I have a niche practice in working with clients who are going through a divorce. I know some of you are probably certified in that area also. If you are, I'd love to talk more. I learned so much from all of you, and I'm working with one person going through the divorce. You guys are working with a couple, and your experience is very different than mine. Please leave a Google review about this workshop. That is a direct request from my marketing director. You could please help her out by giving us a Google review. And this is the QR code, and I think that'll pop up again later. We do workshops every month. And so we talk about what estate planning is. We talk about options for vesting sometimes, and they're free and they're online. We do not record them because it's mostly lay people who are coming to those workshops, and we want them to be able to be vulnerable and ask questions. And so we don't record, because we found that recording those workshops leads to absolutely no questions. So estate planning answers 3 questions generally. What about me? What about my stuff? And what about my children and other people I leave behind? Every adult needs to address what about me, healthcare directives, powers of attorney. Everybody with minor children and real estate needs a trust to address what about my stuff. Other people might also need a trust. But if you don't address what about my stuff, then the law has a lot to say about who is going to get that stuff. And then what about my children and the others I leave behind that I'm worried about? How do we set up a guardianship that is going to get the approval of a judge so that she's going to do what the parents would like her to do? And how do we best take care of the other people that we're leaving behind? Today, we're really focusing on what about my stuff from a real estate perspective. And these are the documents that address the three questions. What about me? Healthcare, powers of attorney. What about my stuff? Revocable trust and asset transfers. What about my children? Long-form guardianship nomination. If you do not use a trust or a will, then the law says, here's who's going to get your stuff. So if you have a children and no spouse, everything goes to the kids. But if the kids are minors, then a judge is going to decide how and when they're going to get their money. People often think that if you're married, everything automatically goes to your spouse, but that's not true. Your spouse does not automatically inherit all of your separate property. So there is a danger zone, especially when it comes to real estate. If one spouse owns a piece of property as a married person and it's 100% theirs, their spouse is not going to inherit that entire property. Some of that is going to be inherited by the children. And I don't think anybody in this room wants to own a piece of real estate with a 3-year-old. So this is a really big danger zone. And then there are just different percentages if you have more than one child or if you don't have children. My website has a probate calculator. You can type in the fair market value of your home, but you do not get to deduct the mortgage. So even if you own a piece of property that the fair market value is 2 million, but the loan is 2.5, you are still on the hook for probate fees based on the 2 million fair market value, $66,000. This is an epic waste of time, money, emotion, energy. It is an invasion of privacy. And anybody who owns real estate in California needs to pay very, very strict attention to these numbers. Now, there are, and it's a little bit outside the scope of what we're going to talk about today. There is a law that says if your piece of real estate is worth less than $750,000, there's an expedited administrative process that you can use. There are also transfer on death deeds. These are highly disfavored. I would never counsel a client to use a transfer on death deed. So who can advise a client on vesting? A lawyer who practices estate planning or a lawyer who practices family law. And the reason for this is we generally have the best understanding of what it means to take title from a divorce perspective, from a capital gains perspective on death, and also from an inheritance perspective on death. A real estate attorney, they are usually not steeped in these areas of the law. So they're absolutely wonderful technicians, but they don't always understand what happens in the event of divorce, what happens on death to the properties. Nobody should ever look to a realtor, a loan officer, anybody at a title company or a mortgage broker. I know that nobody here would ever give their client advice. I hope that nobody here will ever give their client that long list of title options from the title company. And if your client comes to you with that, please just crumple it up and throw it away and get your client to a great lawyer, a family law attorney or an estate planning lawyer. Don't leave your clients at the mercy of the escrow officers and the title officers. This is always the very last thing. I get panicked calls from people, we're closing escrow in 3 days and we have to decide how to take title. Well, you've been shopping for a house for a long time. We could have figured all of this out ages ago. So this really is something when you start working with a buyer, the very first introductions you should make is get them to a lawyer who can help them figure out how are we going to own this property. I think it's a really important first step. I like a team approach for everything. I like a glam squad. I like a professional team. When my clients want to buy a piece of real estate, say it's going to be their first time, I build a team around them. Let's find the right realtor. Let's bring in a terrific insurance broker who can help you figure out if you can afford this house. Maybe we need to bring in a financial advisor to help them really position their assets to get a better loan. We're bringing in a mortgage broker. We have to look at all the facets of making this purchase. I work with too many clients who bought a home and the only insurance they have on the house is what the lender required. So they're woefully uninsured. They can buy this house, get this crappy insurance, go out for a drive. They're all excited. They're not paying attention. They cause a huge accident. They don't have enough liability insurance, and now they're going to lose the house. Stuff like this makes me insane. And it's because I suffer from catastrophic thinking because I am an estate planning lawyer. So I strongly feel that you guys are in a great position to help every single one of your buying clients create a team that they can count on. An estate planning lawyer, an insurance broker, a mortgage broker, everybody that they're going to need, maybe a financial advisor. And maybe you just need to get them to one of these people, one of these professionals who is very highly networked and works from a perspective of team building, of making sure that the client is doing a full 360 when it comes to this home purchase. Okay, so now let's talk about the different types of owners. So maybe someone is buying a property and they are going to be the only one on title. So if they don't do any estate planning, then the person who's going to inherit this house is going to be the person who's closest to them by blood. So it might be their child, it might be their parent, it might be their siblings. It's never going to be their unmarried partner. Sometimes people who are purchasing property on their own are married and they think, well, my name is on title, so it's just mine. Not necessarily. It is really complicated. So whenever you have somebody who is saying, I'm a married person, but my name's going to be the only one on title, they really need to talk to a lawyer because it's very, very likely that unless they have a really terrific prenup, it's not going to be just theirs. And I see this all the time, and it's usually because of the lenders. The lenders don't want the other spouse on title for whatever reason because they don't understand California law. This should always be paired to with a trust to avoid probate. Tenancies in common. So, here in California, we really have two types. There's the type where there's a building with multiple units, and each unit has an owner or, owners, and then the whole building is considered a TIC. These people are very well aware that they're in business together. Often they've gotten the loan together. It's all kind of one big thing. Their thinking is very different than condo owners. They truly understand they're in business with each other. It is absolutely critical that every single member in this multi-unit TIC has an estate plan. The other type of TIC is, let's say a couple is buying a piece of property, and this could be a romantic couple or just, two people. And one of them is going to own 80% and the other one is going to own 20%. When they die, the other owner does not automatically inherit from them. So what happens to the 20% owner when the 80% owner dies if they haven't addressed estate planning? Nothing good. Who knows who they're going to wind up owning this piece of property with, if they're going to be able to continue to live there, etc. They need co-ownership agreements. They need estate plans. They need to address all of the terrible things that might happen if something bad happens to one of them. Then there's joint tenancy. You know what? Well, let me go back because I want to talk about this a little bit more. These TICs can be really similar to condos, like a small building. And I'll tell you a story. One of my girlfriends owned one of 3 units in a beautiful Victorian on Dolores Street. And she lived on the top floor and it was magical. And there was somebody else in the middle and a single man living on the bottom, and they had the shared garden space and everything was fine. Everybody was paying their HOAs and their capital contributions, and everything was just going along until the guy on the bottom floor died. And he died with no documents at all. He was not married. He did not have kids. His parents were dead. He had no siblings. So who started fighting over his estate? His cousins. This went on for 3 years. During these 3 years, no HOA payments, no capital contributions, no property tax payments. So my friends thought, well, we have to address the roof and this place needs to be painted. So we're going to take out some money. We'll take out a loan and then the estate will eventually pay us back. This will eventually resolve itself and we'll get paid back. They could not get a reasonable rate. Then they thought, we just can't take it anymore. We're going to sell. Well, buyers didn't want to give them fair market value because of this issue. The final thing that happened was a raccoon infestation in the bottom floor that had been sitting completely empty and was not being maintained by anyone during all of this time. People who own condos don't think that they are in business with the other people in the building, but they are. So if you have buyers who are thinking about buying into, let's say 10 units or less, any number where if one person, one owner just falls off a cliff and is not contributing anymore, how harmful is that going to be to everybody else who lives in the building? Condo owners think they own just the air and they think that the HOA insurance is all the insurance they need. We help them with this all the time. We provide a lot of support on how to go to talk to the other owners. We pull deeds for all of the other properties. And this is a continuous recurring theme and nightmare. I had clients who owned a duplex. They lived on top and an elderly woman lived downstairs. And we pulled her deed, not transferred to a trust. And I said, how's your relationship with her? How are things going? And they said, oh, she's really lovely, but she really seems to be spaced out lately. And they kind of described a few things that she had been doing. And I said, I think you really need to have a serious talk with her. So they did. They talked to her and they talked to her adult kids. And it turned out that she had early stage dementia. I was able to give a referral to a lawyer who works with that type of client. She got her estate plan done. Her kids became more involved. She's still living there. She has a helper. And she got on medication to slow so results may vary. I mean, we're good at what we do at my firm, but I don't know, that day we were magical. Like it was just such an incredible result. So joint tenancy. I have been told 1,000 times, if I have been told it once, by clients, when I ask them, why did you take title as joint tenants? Because the person at the title company told me that's what married people do. If anybody here is from a title company, please stop it. 1,000 of my clients are not lying to me. I know that this happens, and I really need you guys to cut it out. So joint tenancy is everybody owns this equally, unlike the tenancy in common where you can have 5% and 95%. On death, it's survivor take all. So whoever is alive, they get all of it. Usually, this is used by unmarried couples, but sometimes married couples will do this. It's not always wrong, but what a joint tenancy with right of survivorship does not get you is a double step up in basis. Everybody who works in real estate is obsessed with capital gains, right? So here's what happens with a joint tenancy with right of survivorship for a married couple or an unmarried couple. One owner dies. If the surviving owner wants to sell that property, they are on the hook for capital gains for the 50% ownership that they own. If they decide to keep the property, when they die, whoever is inheriting from them, when they sell that property, they will be on the hook for capital gains from the first person who died, from the date of their death until the date that the second person died. This is not a good tax result. Sometimes it's necessary to do this. Maybe it's a married couple who are coming in and they're using separate property and they're using uneven amounts, but they don't want to do a tenancy in common because they want the right of survivorship. There are reasons to do this. It's not automatically wrong. but it's not automatically right either. The answer to every legal question is it depends. And this one is really, really complicated. And what needs to happen is a lawyer needs to explain it to the clients. This is what you are signing up for. How do you feel about it? And especially newlyweds will be really nervous um, when they're making that decision because they're just tying their money together. So there is no married people always do this. Sometimes married people do joint tenancy with right of survivorship. Sometimes unmarried couples do, or family members do. Sometimes they use TICs. Here's the other option for married people. There's community property, and there's also community property with right of survivorship. The big difference is that if it doesn't have the right of survivorship on it, it doesn't automatically go to that surviving spouse. This is only for married people. This is the one that provides a full step up in basis. So one spouse dies, the place is increased in value $2 million because it's in Palo Alto. And they bought it, 3 years ago. It's worth so much more. And the surviving spouse says, I can't live here without my baby. I can't do it. So they sell, no capital gains. It really protects a surviving spouse from having to deal with capital gains. If the surviving spouse decides, well, I'm going to keep it. I'm going to keep this home. This is our family home. I want to leave it to my children. They leave it to the kids. The kids decide, that's cute, but we don't want to live here. We're going to sell it. They don't pay capital gains. A double step up in basis is incredibly attractive. And so you would think, well, why don't all married people do this? Because we don't know where the money is coming from for them to make this purchase. Years ago, and this poor woman called every lawyer in town. Her mother had given her $2 million to buy a piece of real estate. So she and her husband bought a place, I think in like Menlo Atherton, and 5 years later, divorce. He would not yield on anything because their deed said community property with the right of survivorship, even though he had not contributed 1 red cent to this home. He had her over a barrel because on divorce, the presumption is that this is going to be a 50-50 split of all appreciation of everything. So married people cannot automatically just do this either. It's not that, oh, well, joint tenancy is always the answer. Oh, community property is always the answer. It's complicated. And you really have to look at where the money is coming from. Even with my clients who have had a trust in place for years, and it's not the first time they're buying a piece of real estate, they're savvy. They still know to come and check in with me, and they know I'm going to ask them a bunch of questions. Where is this money coming from? Oh, you just got an inheritance. That's your separate property. Do you want to take title as community property? Should this just belong to you as a married person, but your sole property? Let's walk through the options and figure out what is best for your family and what your intentions are for this piece of real estate. It takes about 20 minutes for me to show them the options, and then they sit and they think about the decision that they need to make. Because it's not that I tell them what they need to do. I show them the tax implications. I show them the implications on divorce. And then they have to sit down and really get that feeling in their gut and in their heart and have a discussion with their people as to what is the best result for us? What are we trying to achieve? Okay. At least 5 times a month, I get an emergency email. We are closing escrow in a week and we need to create a trust before we close escrow. My question is there a court order requiring you to do this? And the answer has only been yes, 1 time in 8 years. We absolutely want to see real estate held in trust in California to avoid those insane probate numbers. We do. However, taking title as trustees for a married couple, the presumption is community property. And that means that 50-50 split on divorce. People really need to take the time. Where is the money coming from? What if we get a divorce? Is the double step up in basis what we really want? Compared to, do I want to be able to take my money out if I get a divorce? So don't automatically think, oh, well, if you have a trust, then you just automatically take title as trustees. It is really expensive for the clients to go back and fix all of this. It requires family law attorneys drafting post-nuptial agreements to unwind what the couple did the first time around. This is tens of thousands of dollars. You will never get another referral from these people. It's really, really tricky to unwind incorrect vesting. And this is one of the biggest mistakes that I see is this, well, we have a trust, so we automatically take title as trustees is dangerous. There should be a deed that states the characterization that says tenancy in common, joint tenants, community property, with or without right of survivorship, whatever it's going to be. And then a second deed that transfers to the trust or trusts. Because sometimes married people each have their own trust. If it's a tenancy in common, often we're dealing with friends or unmarried couples. For joint tenancy, we're all often dealing with unmarried couples. So there are multiple trusts that need to be created. We talked about the tax outcome, community property. I love that double step up in basis. It's magical. Often your unmarried couple clients will say, because you're chatting with them, you're like, oh, so why aren't you guys married? And they'll say, oh, our CPA. Get them to an estate planning lawyer. If they are real estate people, what their CPA is telling them about their year-to-year tax may not be the full story, because this double step up in basis can really protect a surviving partner from insane taxes during a time of grief. And we talked about this joint tenancy that you get a step up at each death, but you don't get that double step up. Sometimes people want to take title in a legal entity. And sometimes your clients are having their CPA create an LLC, or they're going on LegalZoom and they are doing this nonsense on their own. Please get them to a lawyer. Most people think, oh, well, I have an LLC, so now I have asset protection. No, you don't. In order to get asset protection, you actually have to operate your LLC like a business. There are all of these things that you need to do, keeping the money segregated, doing annual minutes. It's well beyond all of the expensive filings that you have to do with the government. There are things that you need to do as a business owner who owns this LLC. And so if you know that your clients are trying to do things like create an LLC on LegalZoom and buy a property and then put that on the market with Airbnb and VRBO, please get them to a lawyer. They are putting themselves in a very dangerous position to lose not only that house, but their personal assets. These are really scary, and I do talk clients out of this once or twice every year. Clients will say, I want to buy a piece of property, a ski place with my friends, and there are 6 of us. And my first question is always, who's the lawyer? And there's never a lawyer. So doing these deals really requires a very large team where every member of this LLC has the best possible insurance, including terrific umbrella insurance done by a really reputable broker. They need to have a lawyer involved to create this LLC. Everybody needs life insurance to pay off their portion of the mortgage if they die. And they need to have agreements as to who owns what. What happens when one of us dies? They need a rule book. They need an operating agreement. These are not simple things. And so if you have a client who's pushing back and just saying, well, we just want to buy this place and, don't worry about all of that, I don't know. It just makes me uncomfortable. So bad mistakes. I've seen a few. Here's some unexpected consequences. A married person without a prenup. So my client bought 4 investment properties with a friend of his, and they were renting them. Now, I pulled the deeds, and it turned out that this friend was not on title to the deeds, but the friend was paying the property tax, and they were sharing in the income from the rents. And I explained to him These people do not have a prenup. And I said, listen, you used married money to make this purchase. And when you die, everything goes to your spouse and your buddy gets nothing. Um, it did not go well. And the last time I saw them, they had sold all of that property um, at a loss. It was a mess. A married couple getting money from a third party and they take title as community property or community property with right of survivorship. I shared with you the woman who, she got that 2 million from her mom to purchase a property. You know, people are so lovely and trusting. We would think, oh my gosh, $2 million, you'd think there would be a contract and lawyers involved, but families don't often do this. I think it's important to put a client through their paces, and it's like, well, where are you getting the money from? You guys all know where the money's coming from, right? Um, where's the paperwork behind all of that? Have you talked to a lawyer about what this means? You can really help somebody. And this may be a problem that doesn't come up for 5, 10, 15, 20 years. But if you get ahead of it now, maybe there won't be a problem down the road. Lack of co-ownership agreements. Oh my gosh. So many people who own real estate together and there are no rules. Um, what happens when we need a new roof? And brother and sister have bought a piece of property with their spouses, right? So brother and his spouse and sister and her spouse buy a cabin in Tahoe. And then somebody loses their job. So they can't make the mortgage payments. But there's no contract saying what is supposed to happen. Really, really dangerous not to have these ownership agreements. This was a deed that I saw. A woman called me and she said, my husband and I own 50% of a property, and my brother Jason, no, she said, my husband and I own 2/3 of a property, and my brother Jason owns the other third. And this is what the deed said. Lisa and Gary, a married couple, and Jason, a single man, as joint tenants. So because we have a married couple in there, I'm not sure that Lisa and Gary don't own 50% and Jason owns the other 50%. I don't know what this means. And this was written by somebody at a title company. I have no idea what this means. And I showed it to real estate lawyers. I have showed it to other estate planning lawyers. Like, well, who knows? So who knows when one of them dies what the local assessor's office is going to say? Who knows when one of them dies what the probate court is going to say? This is a mess. We sent them to a real estate lawyer to try to help them to untangle this. There is no sibling exclusion when it comes to transfers. And so if they do transfer it so that Jason does clearly own 30%, that was going to trigger a partial reassessment. This was an absolute mess. So please be very, very careful and make sure that you don't rely on the title company when you have multiple owners like this, that a lawyer is reviewing the deed before it's signed by your clients, because this is a mystery deed. We talked about assuming you're not in business with other owners of a tenancy in common or a small condo. And this is a really big one. Assuming that property you owned before you were married remains your own separate property. I work with a lot of people who are getting married for the first time in their late 30s and 40s, or people who have been married before and now they're, getting married again, and they have property. They own things. But there's a mortgage. And if you don't have a prenup, then the wages that you're earning, that you're using to pay down the mortgage on that property that was yours before you got married, you might slowly be allowing your marital community to take an ownership interest in what you think of as your separate property. Every time I explain this to clients, it makes them completely insane. A prenup could resolve this really clearly and easily, but people don't think about that. California is so diabolically complicated. And it's terrible. We're in love. Let's go see a lawyer. We're going to buy a house. Let's go see a lawyer. It just sounds depressing, but I promise you, if you get your clients to the right lawyer, it should be a really empowering and enriching experience, because education and knowledge just puts them in a better position to make really great decisions for themselves, not inadvertently hurt each other, not inadvertently make mistakes. What if they own this separate property with a sibling? Now you're putting the sibling in the position of owning a property not just with their sister, but with their sister's spouse. It's not fair, right? It's not fair. So more lawyers it seems to be the solution. Um, so a good estate planning lawyer doesn't just sit within the four corners of the documents. They shouldn't just be technicians who are asking the client, what do you want? And they write it down and they have the client sign the documents. And that's what a lot of us do. Well, I'm going to say them because there are two types of estate planning lawyers. Some estate planning lawyers do operate that way. There are a lot of us who do not. Um, Taking a team approach is critical for an estate planning lawyer. Clients need great insurance. They need great realtors. I don't want them buying real estate off of Redfin. I really don't. You guys are the experts. You know what questions to ask. You guys know how to read the disclosures. The clients don't. They need great business entity formation lawyers. They need incredible insurance brokers, especially in this super bizarre market where you're with one captive agent, you're super happy, everything's great. You buy another house, and the agent says, "I'm sorry, we can't insure that house for you." Oh my gosh! And so many people who are going from renter to owner, and they have bought all of their insurance from TV commercials. Really scary. They don't have umbrella insurance, and they just don't have the knowledge of what to ask for, of what they really need when it comes to protecting their biggest asset, their home. And a really good estate planning lawyer should be collaborating with all of the advisors, making sure that vesting is done properly, making sure the CPA, the financial advisor, the insurance broker all know that a trust has been created and here are your marching orders. And also giving referrals to other family members, giving referrals to other owners of the real estate, whether it's the TIC, the condo, family members, whoever it might be. Um, I'm sure that most of you own real estate, and because you own real estate, you have a trust. Make sure that your insurance is perfect. Make sure you have enough life insurance to really take care of the mortgage and take care of your people when you're gone. Make sure you have communicated the fact that you have a trust with your CPA. Talk to your financial advisor often and often people don't talk to their financial advisors about their real estate. Talk to your advisor about your real estate. Show them your deed because they can't help you with just the cash. They need to know the full story. Your business lawyer, that's who you look to help you with asset protection. Transferring your property to a revocable trust, no asset protection, none. You need an LLC, you need a corporation, you need some kind of an entity that's going to provide you with that asset protection when you do all of the underlying things that you need to do. I have a great business lawyer, and she does all of that for me every year. I pay her under $1,000, and it is great because it is boring work, and she makes sure that it's all getting done absolutely correctly. You need to make sure that your family has their affairs in order. Make sure that your chosen guardians, your business partners, co-owners in real estate, that everybody has an estate plan and that it's up to date. That everybody's insurance is up to date, because if you're all connected, whether you're connected financially or through real estate, you're all connected. And what you don't want is to be going through the court system during a time of grief. It's something that I think we all owe each other. So how do you vet an estate planning lawyer? And I guess you guys must know a lot of us. And so I would say, look at their education. I have a master's. Not everybody will, and it's not necessary. Maybe they are a certified specialist. I'm not a certified specialist because I can't take one more exam. I just won't do it. I won't sit for another exam. And a lot of people are, but that's not necessary either. How much time and care are they spending for each client? That's really important. If they say to you, we can do the whole thing in an hour, please don't send your client there. That's not a good idea. You want to know, how long have you been doing this? How long, and do they have other areas of practice? If the lawyer is doing estate planning, family law, entity formation, civil litigation, this is a danger zone. estate planning is very serious business. You cannot get a master's in every area of the law. So it's not something that any lawyer should dabble in. Emotional intelligence is really important. Clients don't want to tell other people that their kids don't like each other, that they own this piece of property with someone, but they're deeply concerned about that person's mental stability, about that person's ability to protect through insurance, like whatever it is. They don't want to speak disparagingly of other people. But we need to pull all the skeletons out of the closet, and if we're really going to help somebody, right? So we need to create a space where people can be very, very open with all of their fears, not just sharing their goals. The lawyer should use software. They just should. Um, the law is always changing. And unless it's a really large firm that can handle all of the updates to the law and all of the best practices, I think it's really difficult for a small shop to just rely on their own forms. Um, a good indicator of how on point an estate planning lawyer is, they shouldn't be naming guardians in a will because it's an invasion of privacy. And if the lawyer says to you, "What are you talking about? That's crazy," you don't have to talk to them anymore. You just let them go. You can tell them to call me and I will explain it to them because we all need to get better at this. Um, do they charge more for a plan that doesn't just say so and so gets X and just give it to them, right? So and so gets their money at 25, 30, and 35, or when I die, just distribute it. There should Lawyers shouldn't charge more if you want to hold some money in trust for a period of time. They just should not be charging more for that. Um, is there is the estate planning lawyer going to create a relationship with this client? I see my clients every 3 years, even if they don't want to. I drag them back because I'm really worried that their trust doesn't have all of their assets in it. And I'm really worried that their trust contains some things that might eventually cause harm because Congress has changed a law or California voters have changed a law. You guys know about Prop 19. You can imagine the amount of work that we had to do after Prop 19, because if you left, say a couple left the primary residence to daughter and the vacation home to son, and that used to be apples and apples, equal value. It's not the same anymore. Daughter moves into the house, Prop 13, Prop 19, amazing. The son has the vacation home, nothing but reassessment. These are not equal gifts anymore, and we need to talk about it. And we never know what's coming around the corner. And it's really important that the estate planning lawyer is going to collaborate with all of the other advisors. I have absolutely spoken to my clients' realtors, their financial advisors, CPAs, insurance brokers, family law attorneys when they're doing prenups. It's really important to take that team approach. This is our client experience. I offer a free 20-minute consultation. I will always talk to anybody. You guys want to send me one of your clients to talk about vesting? I will talk to them about vesting. I'll offer them a free 20 minutes. I'm not going to give them advice. I'm going to give them the information so that they can make an informed decision. Because nobody should really tell someone how to take title. Because I hope the big theme here was it depends. And the last thing it depends on is the client's heart and gut as to what is the best thing to do in that scenario. We spend 2 hours getting to know our clients. We spend 90 minutes explaining the documents to our clients. Notarization is online or in person. We have a meeting to talk about how do we get this stuff into the trust. And then we follow up and we see them every 3 years and we're ultra involved and paranoid. So free meeting on vesting. And I would like to do this when you meet the buyer, when they sign with you. It is too stressful for them when they've chosen the house and they're in escrow and the loan officer is all over them asking for their 4th grade report card. It's too much. This is something that they can figure out really early on. And this is who we work with. We do not work with anybody who doesn't support the queer community. We work with all types of families, married, unmarried, artists, creators, performers, business owners. And this is me and how to reach me. And now we can do inquiries and chatty banter.
Great. Well, thank you for such an informative presentation. You've made it very clear, and Um, I, I'm sure there are some questions,
There
so
are some
let's take a
questions.
look here.
Yeah, the first one is, what happens when joint tenancy is broken and how can it be broken? Okay, so any member of a joint tenancy can break it. They can say, I just don't want this anymore. I don't want the right of survivorship. And they can just submit a new deed that says no more right of survivorship. Also, transferring your share of a joint tenancy to your trust, that severs the survivorship. And so you have to be really careful with this, because what we don't want to have happen is, let's say it's a brother and a sister, and I'm working with a sister. She creates a trust and she wants her portion of this joint tenancy to go into her trust, and she wants to leave it to her kids. So now the survivorship is broken. If brother does not transfer his share to a trust, then when he dies, his portion is going to go through probate, and it's either going to go to his kids, his parents, or maybe it would go to her if she's the only one left alive, but it's going to go through that probate process. Once it's broken, you can't unbreak it. Once the joint tenancy, the survivorship is broken, that's it. There's no second bite at the apple. So you have to be really, really careful and strategic when you're doing this work. And this is true of community property with right of survivorship. Also, for those of you who work with divorcing clients, they can absolutely sever that survivorship. Um, it's technical, it requires a couple of lawyers, and it is a tactic to be decided on by the divorce lawyer. But some divorce lawyers don't know about it, and you can look like the conquering hero if you mention it to the client. Um, I know it's tricky ethically for you guys though, because you're representing both parties when you're doing this. So, proceed with caution. Oh, what happens if you have a domestic partnership? Okay, there are two kinds of domestic partnership in California. There's the one where you go to the city and you get put on your boo's healthcare. That's all that is. And it's nowhere near marriage, and it's not recognized by the state for anything. That's just a healthcare thing. If you are registered with the state of California, that is like a marriage. So if domestic partners are both on the deed, they can take title either as joint tenants or as community property. Um, but the question is the mortgage. So mortgage, that's something that is a question for the lender. And it's tricky because lenders are national and you're not married under the federal scheme. So what happens, right? So I think anytime we're working with domestic partners and they're looking at purchasing real estate, this is something that I have to get them to an insurance, to a mortgage broker who understands domestic partnerships and knows how to help the couple present themselves in a way to get both of them on the mortgage, so that if we do lose one of them, the other one isn't left flailing, because sometimes that surviving partner wouldn't qualify, right? So it's tricky. It can be really, really hard, and having that broad network of mortgage brokers who work in different disciplines with different types of clients is really important. What kind of software should estate planning lawyers use? So I use Wealth Counsel, which is recognized by the American Bar Association. There are a couple of other types. LexisNexis has one. Um, I can't remember the names of the other ones. You just mentioned a preference to connect clients when signing the buyer rep agreement. She has a client who's closing in 2 weeks, and they've selected to hold title as community property right of survivorship, but may consider moving the unit under a trust to avoid probate. Would it make sense for them to reach out to you now or after close? I don't know how they decided to hold title as community property right of survivorship. I don't know if they've spoken to an attorney and if they understand what that means. So have them call me now. Have them call me now. Um, it's not difficult to move a property into a trust after close. And I really prefer a trust, a grant deed that says, this is how we own it, this is how we're vesting. And then we do a trust transfer deed into the trust. Really simple, really easy. We do them every day. Those were the questions. Those are good questions.
They are good questions. Any others that we can answer while we have Patricia here with us? There's one. Well, there's a comment. Thank you, Ed and
Hi,
Teresa.
Teresa. So nice to see you here. Thank you. And actually, I recognize quite a few names on the participants list. And thank you so much for taking the time. This stuff is really, really complicated and sticky. I work with a lot of realtors, and you guys are in the trenches and you don't always get it right. You can absolutely come and, ask me. Always just ask me. I have such a soft spot for realtors. But I'll tell you, incredibly sophisticated people who are real estate investors get this stuff wrong. Um, Especially if they're not from California, but even if they're California born and raised. The laws here are just a mess. There's overlapping laws, competing interests. Prop 19 is the devil's work when it comes to inherited real estate. It's really hard. It's really hard.
We do have one more question. What about name changes?
Oh, yeah, that happens all the time. So generally when a client does a name change, then sometimes we can just send them to the title company. And they go in with their new name, and then the title company will do like that. It's not really a correction deed because the former deed wasn't wrong, but they will file a form of deed that updates that. And then you want to do it with a supporting document. Sometimes we're working with clients who um, just changed their name because they just got married or they transitioned. And so maybe their old deed says Mary Smith, but now they are Mark Smith. And so we'll say Mary Smith, who took title as Mark Smith. I think I just said that backwards. And then provide the supporting identifying. Usually the recorder's offices will take that when we do an electronic submission. Every once in a while, I'll get a phone call. San Francisco's really great with that stuff. Some of the more rural areas tend to get confused. They get the married people, but they're not so good with the transgender name changes. But it's usually like a 5-minute call, and then we resolve it because usually they're just curious. Like, I haven't seen this before. What is this? Yeah, so name changes happen. What can be really tricky with name changes is, and you guys know, you got newlyweds and they have to do the notarization, but they don't have their ID yet. So you have to get the two witnesses. Um, that's usually the biggest stumbling block. You can't have them sign online because they can't prove who they are.
Okay, well, it looks like that will probably do it for us today. Well, thank you
Thank you
so
so
much,
much
and
for
thanks for
having me.
sharing your contact info and the QR codes. Just a reminder to all of our members who are here today, and you can tell your friends that the recording will be made available on the SFAR video library. So be on the lookout for that once it hits. And again, thank you so much for being here today, Patricia. I really
You know
appreciate
what?
it.
A few more questions came in. Okay, so um, I just sent them the how to hold title document with the title company. What's the cost of the initial consult? The 20-minute consult is free. It's free. People do not have enough access to legal, and I'm happy to help. Um, oh, the caretaker took the elderly owner off title. How? That wouldn't be somebody for me, but Hector, reach out and let's get you to the right lawyer because that is awful. Um, yeah, that's elder abuse. Oh God, on that note, that's sad. Okay, we all love real estate. Everybody have a happy home, and remind the clients that estate planning is really important and they should budget for it. Because what happens is buyers buy the house, and then it's landscaping and window dressings and couches. And then I see them 3 years later, and that whole time they never had umbrella insurance. The house wasn't in a trust. They took title the wrong way, and it's all been a hot mess. Early, early, early in the process, get them to an estate planning lawyer. Avoid the danger zone.
Okay. Well, I think that'll do it for us today. Thanks again, Patricia. Have a wonderful rest of your day, and thanks everybody for joining us.
Thank you.
You're welcome.